Well, good afternoon. Thank you for joining us today. My name is Carrie Filiberto, and I'm the Deputy Executive Director and Counsel of ConsensusDocs. We appreciate your participation in today's 90-minute webinar. Today, our panel is going to discuss key contracting issues for design professional agreements and the differences between the ConsensusDocs and AIA owner and design professional contracts will be used as examples. A copy of the PowerPoint presentation will be emailed to you after the webinar. You will have an opportunity to ask questions of our speakers today. Please type your questions in the questions box, and we'll have the speakers address them at the end of their presentation. I would now like to introduce our esteemed speakers. We have Melissa Orion Beutler, Tim Gibbons, and Frank Riggs. Melissa is an attorney at Holland and Hart's Las Vegas office and also works in the Salt Lake City office. Her practice focuses on counseling parties on virtually all aspects of the construction project, from drafting and negotiating contracts, counseling on project-level resolution of claims, and dispute resolution. She is also a member of the ConsensusDocs Advisory Council. Tim is a member of Chambliss, Bahner, and Stophel, PC, in Tennessee. In his practice, Tim has handled numerous construction and related contract matters. He has also lectured extensively on a variety of construction law topics and is a founding member of the Tennessee Association of Construction Counsel. Prior to attending law school, Tim practiced as a licensed architect. Frank is the chair of the construction practice group for the Atlanta-based firm of Troutman Sanders. He has been a practicing construction lawyer for over 35 years, representing the interests of owners, contractors, construction managers, and suppliers. He serves as a member of the AGC Contract Documents Committee and the ConsensusDocs Drafting Council. He was named Best Lawyers 2012 Atlanta Construction Law Lawyer of the Year and is a graduate of the University of Virginia School of Law. We are very lucky to have such prominent construction industry attorneys for our presentation today. I would like to take just a brief moment to talk with you and provide you with an overview of ConsensusDocs. ConsensusDocs is a coalition of 38 design and construction industry associations. These associations come together to write best practice documents. Some of the things that make us unique and have happened in the past 5 years is that we've increased our coalition by 90%. We started off with 20 coalition members and now have 38. That we've experienced significant and steady user growth despite our somewhat down economy. We have released the first documents in a variety of areas, including IPD, BIM, green, fed-sub, sub-sub, joint venture agreements, and more. We have a wide variety of free resources available for you on the website, and one of the more prominent resources we like to reference is the ConsensusDocs Guidebook, where the coalition members issue spot for their members. Currently, that is a free download to the general public as well. The most exciting thing in 2012, I think, for ConsensusDocs was the release of a brand new technology platform. With this new platform, you have 24/7 access via a secure cloud-based technology platform. We converted the documents so that they are now editable in Microsoft Word. We have a unique collaboration platform with version control and a variety of free comparison and helpful tools on the platform. And with that, I'd like to turn it over to our speakers so that they can get into the substance of our webinar today. And with that, Melissa, if you turn your phone off of mute, we'd love to hear about preliminary assumptions, project data, and contract documents.
Great. So our first topic, we've combined a couple things that generally relate to incorporating within either architect agreement the requirements of that particular architect's scope of service. And I think most lawyers who review design professionals would agree that this tends to be one of the areas that project teams without legal involvement are most likely to overlook or sidestep. I mean, frequently I'll see either an AIA or a ConsensusDoc architect agreement where there's nothing incorporated or attached that describes what it is the owner is expecting the architect to do. Sometimes you'll get a simple program description attached or a basic schedule, but both the ConsensusDoc and the AIA forms, because these issues are so project-specific, neither has a sophisticated default template to step the parties through what to attach or incorporate as a program exhibit or initial information. So frequently the parties will leave it blank or attach something very simplified as the information that's incorporated in. Carrie, if you'll go to the next slide. So hitting first the ConsensusDoc 240, which is the ConsensusDoc Owner Design Professional Agreement. One of the significant revisions that we did to the entire document family with the 2011 revisions was to attempt to add more precision to what is a contract document. And the way that that is addressed in the ConsensusDoc 240 is that the owner's program or other project data defining the project is attached as Exhibit A to the 240 contract document. And so then it's incumbent upon the parties to articulate what's included in the owner's program. Whether that is incorporating a project description, program information, square footage information, a discussion of description or goals of the projects. That is incumbent upon the parties to incorporate and add that information. In addition, with respect to existing owner information that's provided to the architect, the section that talks about the contract documents in Section 2.5 references owner information provided pursuant to subsection 4.1.1, and then it requires the parties to actually individually list the documents that the owner provided that the architect is entitled to rely on. And the reason for that is frequently the architect will ask for, well, let's see the record documents or other data that the owner might have related to the building that the owner is providing for the architect's information but doesn't intend for the architect to rely on. Obviously, most building owners who've done any retrofit project identify substantial numbers of errors and inconsistencies between the existing record drawings and the as-built conditions in the field. So that the process behind individually scheduling the documents that the owner intends the architect to rely on is to help the parties work through that conversation of, are these record documents being provided for the architect's use in consultation, or are these documents that the architect is being entitled to rely on? So hopefully eliminating some of those disputed issues regarding, well, the owner provided me this information, I was supposed to rely on it, hoping to help the parties have that dialogue at the beginning of the contract to avoid issues further along. The ConsensusDoc 240 also sets out, in the template, places for the parties to populate with who their representatives are, who their consultants are, the key personnel responsible for administering the contract. And those are at the respective sections identified in the slide. And then regarding pricing and revision, Article 3 of the 240 indicates that the design professional shall revise the documents without compensation under identified circumstances, mainly if the documents haven't previously been approved by the owner, or there's identified constructability issues or revisions needed to clarify assumptions, that those are items that the architect is required to revise. But once the owner has approved a set of design deliverables, unless there's a constructability issue identified, if the owner makes changes after that point, the architect is entitled to get additional services for those revisions. Carrie, if we go to the next slide. And for purposes of the presentation today, we're focusing on the B101 Architect Agreement in the AIA series, recognizing that there's also the B103 or the other B series documents, but given just for purposes of having a document, we're using the B101. Similar issue with the way that the AIA document identifies initial information or contract documents. It's simply a plug-in for the parties to insert in Article 1. And it defines the term that the AIA uses is initial information. Now the parties can either define it in the blank or attach an optional Exhibit A. and it gives a list of recommended information to include, like the project site and program, or the party's consultants, owner's cost of the work, or budget for the cost of the work, but there aren't blanks or templates for the parties to fill out. So frequently I'll either see an architect agreement with that information completely blank, or some project description that doesn't accurately articulate what the owner is expecting the architect to provide attached as an exhibit. It does, the B101 does include a section for the parties to put in the anticipated start of construction and substantial completion date in the design agreement, as well as the parties' project teams and anticipated consultants. Section 1.3 of the B101 indicates that the owner and the architect may rely on the initial information. However, the parties recognize that it might change, but if it does, if the initial information changes, then the architect's schedule, services, and compensation can be adjusted, which presents an issue in circumstances where the parties don't articulate with precision what the intended scope or program or project is, or if at the time the architect agreement started that dialogue hasn't been very developed, then the architect has a fairly broad right to seek additional compensation or schedule based on changes in the initial information. So, I mean, that issue makes it additionally more important for the architect or for the owner to identify what the initial information is or establish the parameters that are in place at the time that the architect is engaged. And then in Article 4, there's also a provision that if the architect's services extend beyond a certain date that's specified, the architect's entitled to additional compensation for providing services during the duration of the project. All right, next slide, Carrie. All right, that takes us to ownership and copyright.
And that's where I'll take over. And if you go ahead and go to the next slide, that'd be great. This series of both topics I'm talking about today are tied strongly to technology, and in particular the changing technology in how you produce and communicate design drawings. As Carrie mentioned in the intro, during my fossil stage, I was an architect, practiced for 7 years as a licensed architect, and we did all our drawings by hand back in the 1970s and into the early 80s. The technology, there was a brief period where we would take the drawings we did by hand, and then through photographic processes and overlays, we could do more things with the drawings than we could simply drawing by hand. But of course, what really changed the entire methodology of how you produce design documents was completely revolutionized by the advent of CAD. Just to give you an idea, one of the firms I practiced with bought some of the early CAD stations in the early 1980s. As I recall, each individual station cost $75,000 in the early 1980s. So extremely expensive, extremely limited capabilities for what you were paying for. Of course, what happened as CAD developed, cost went way down, the capabilities, and in particular the storage capacity of the computers went way up, and the next sort of big development from CAD was we went from just drawing lines to being able to add digital information in the lines, so to speak. The lines then meant something instead of just being a couple of lines for a wall, that you could code it and say, okay, this particular wall is 2 layers of 5/8 inch sheetrock on 3.5 inch metal studs at 16 inches on center. you could put that information in the drawing, so to speak. And of course, as it went further from there in the digital age, we got to the point of interactive databases and now cloud computing. So it's important to keep in mind that the topics of what does a designer produce have changed dramatically in the sense of how that's communicated. And it's really just been in the last 30 to 40 years that that's occurred. Next slide, please. As you can tell, there are a number of competing interests in the idea of whose information, who owns the information. Owners may need to protect proprietary information. I mean, we have, in my practice, drafted contracts that begin with the premise that all intellectual property is owned by the owner. That's particularly true where there are large manufacturing plants, processing facilities where the layouts, utilities, and services, how they're arranged, are proprietary to the owner. The competing interest, of course, is the designer's authorship. The designer has come up with these drawings, has come up with this information, and so historically it was the designer's property. You have other intellectual property rights involved as well. You have other protectable interests involved as well. I mean, I'm reminded that even certain types of architectural designs themselves are protected under the Lanham Act from time to time. So there's lots of interest out there. Next slide, please. Now, going to how the ConsensusDocs treats the ownership of the documents, drawings, and data as compared to the AIA, and as Melissa mentioned, we'll just be comparing to the B101 because of time limitations, and we're looking at the ConsensusDocs 240, although obviously both ConsensusDocs and AIA have other contracts. ConsensusDocs starts with the idea that the owner owns the documents, the drawings, the data, provided, of course, that the owner pays. ConsensusDocs starts with the premise that the owner does not get the copyright. And if you'll, the specific reference is Article 10 of the ConsensusDocs 240. It just says specifically, straight out, the owner shall receive ownership of the property rights except for copyrights of all documents. It starts from that premise. The next provision in that same document, 10.1.1, gives some more fill-ins where it says, okay, owner, you can obtain the right to the copyright, ownership of the copyright, provided you pay the amount set forth in the box. So the parties can determine immediately, okay, owner, if you want the copyright, it's going to cost you X, fill it in the box, it's yours. And the owner maintains the rights in those documents and information, provided that the owner pays for them and pays in accordance with the agreement. Now, of course, the other side of the coin is the AIA's traditional approach, which is that the architect and its consultants own the instruments of service, and the instruments of service are really everything produced by the designer. They retain the rights, including the copyrights, and all the documents, and that's really, to my knowledge, been the traditional approach of the AIA, and understandably so. I mean, they want to protect their members, and so that's been their approach ever since I've been looking at AIA documents, which is quite a while. Next slide, please. I've already covered the fact that under ConsensusDocs 240, the owner can get the copyright contingent on making the payment. It's interesting that the ConsensusDocs also provides that if, as I think Melissa mentioned, sometimes you get these form documents and people don't fill in some of the blanks that maybe they could fill in. If people do not fill in the blanks on getting the copyright, then it remains with the designer. The AIA approach to that same issue, as you can tell from the other side of that slide, is that the architect will grant a non-exclusive license in the instruments of service solely for certain uses to the owner. And the use generally is in order to get the project built. Next slide, please. Under ConsensusDocs, you'll see that the owner is able to use the documents to complete the project after termination for convenience or termination for cause, again, provided the owner pays. Interestingly, and it's something that's worth pointing out, the ConsensusDocs specifically says that that use of documents by the owner includes making derivative works, which is, of course, a term of art under the Copyright Act, but derivative works can be extremely important to owners in performing work on additions. And I imagine if the owner has some sort of a cookie-cutter project that the owner may want to put up otherwise with some changes, the owner would be able to use documents and make derivative works because the owner has the intellectual property rights in them. Under the AIA, you'll see that the non-exclusive license that is granted to the owner terminates if the owner doesn't pay, if the architect terminates for cause, and if the owner does not pay the additional amounts required in a termination for convenience. You'll remember that under the AIA documents there's a provision for additional payments to the architect of certain sums if it's a termination not for cause. Next slide, please. We're going to stay on this next slide for a while because there's a lot of information in these two specific documents, and these are the ConsensusDocs 200.2, and under the AIA they have the AIA E201. I will tell you that the ConsensusDocs 200.2 is an extremely detailed agreement. And it is, I think it's about 12 pages. It's a 14-page doc. It's about 12 pages of text as compared to the AIA document. It's really about 2 pages of text. And I did want to go through just a very few points about the ConsensusDocs approach, which is it has a number of people who are identified in the document. You have an IT administrator in Section 3.1. You have an IT management team in Section 3.2. You have an IT management coordinator in Section 3.3. You have a webmaster in Section 3.4. In another section of the document, you have someone that may be a third-party service provider. All these parties are identified. All these parties have roles to play in how the information is transmitted. And I will say this, that particularly for the lawyers who are listening out there, I think it's worth getting the ConsensusDocs 200.2 if for no other reason than to just go through and review Section 4 of that agreement, which is the system parameters. The system parameters covers an array of topics that is sort of difficult to imagine. I mean, for the lawyers in the crowd, we see some of these issues in our current wars that we fight on electronically stored information and discovery of electronically stored information. Well, when you look at the ConsensusDocs 200.2, I mean, it just lets me know, if I didn't know before, I don't have a clue about what's out there. The system parameters on the ConsensusDocs includes permitted file formats, and it lists things I don't even understand what they are, but several different formats. It lists parameters and protocols for hardware and operating systems. And again, it's a lengthy document, but it gives the parties the ability to fill in what is the equipment we're going to use, what type of workstations, what type of CPUs, what types of monitors, what types of input drivers, what types of printers, what types of plotters. It's really worth going through that, and it includes listings of software requirements, transmission and access requirements in 4.5, security and encryption requirements in 4.6. It talks about tests, protocols, upgrades, and also covers the proprietary and confidential information. Under both of the AIA and the ConsensusDocs documents, there is an indemnity under the ConsensusDocs. It is a mutual indemnity for damages that arise out of a user's failure to conform to the protocol. Under the AIA, it's an indemnity by the receiving party for unlicensed use of the modification. I will note that the AIA also has its own project protocol table in E201, and that's section 3.1 of that document. I'm the first to admit that the technology involved is significantly beyond my capabilities, but I could tell you it's certainly worth a read through the ConsensusDocs document just to see the varieties of capabilities and electronic protocols that are available out there and in use. And I think with that, we go to the next section.
Thank you, Tim. Let's talk for a minute about the standard of care as it's treated in the two sets of documents. And what we're talking about, of course, is the standard by which the design professional's performance is going to be judged, which is important to both the owner and the design professional. And there are some differences in how the AIA B101 and the ConsensusDocs 240 approach that standard of care definition. Next slide, Carrie. You'll see to begin with that both sets of documents contain a very similar description of the applicable legal standard of care imposed on the design professional. And both definitions, although they're worded somewhat differently, are consistent and consistent with what you would find in a general common law standard of care imposed on professionals in performing services. The standard is, the skill and care required of like professionals in the area who are involved in similar projects. The definition you see in the ConsensusDocs was added in 2011, although I don't think the addition of that language really changed anything. It simply express what was already implicit in the document. Next slide, Carrie. ConsensusDocs, though, goes forward with a potential imposition of a somewhat higher standard of care for design professionals. And you'll see in this slide in the reference to Article 2.2 and the reference to the relationship of trust and confidence language. That is language which typically signals the creation of a fiduciary relationship between two parties. And although I think it's probably unclear how courts might interpret that language, an owner certainly may argue that the design professional has agreed to a somewhat higher standard of care as a result of this Article 2 language. A fiduciary relationship standard, of course, requires duties like loyalty, good faith. It might require that the design professional look out for the best interest of the owner. And although most owners would assume that a design professional owes them those duties anyway, there is a difference between a common law duty of due care and a fiduciary duty. And let me just illustrate that point with an actual case example that I saw recently. Take the case of an architect who had previously designed a building next to a project now being designed by that architect for a different owner. And in the earlier project, the design professional became aware of some unanticipated soils conditions. But with respect to the second project and the second owner, the design professional did not warn the second owner of the prior discovery on the adjacent property, and similar unanticipated soils conditions are encountered with the second project. Now, ordinarily, that design professional would have no common law duty to disclose that information to the second owner. But if the design professional has a fiduciary relationship, then that owner might successfully contend that the design professional failed in its duty to look out for the best interest of the owner. Most owners, I suspect, would prefer the potentially broader standard in the consensus docs, although I'm sure that design professionals would point out that there may not be insurance coverage for a design professional's breach of a fiduciary duty, and an owner certainly should understand that potential insurance gap going into a project. Next slide, Carrie. You know, in addition to establishing the standard of care, both the consensus docs and the AIA B101 address in somewhat different ways what I would call a standard of completeness with respect to the design professional's duty to provide a project design. If you look at the language quoted here, you'll see that the Consensus Docs 240 describes the scope of the design professional's duties in creating a complete design in a somewhat, I would say, more inclusive way than the AIA. The AIA speaks only of the design professional agreeing to do what the contract specifically requires. And the AIA language regarding the completeness of that design product is a little less demanding. There may not be a big difference between the two, but the language differences suggest to me that an owner may be better protected by the consensus docs, both in terms of the standard of care definition and the standard of completion. Next slide, Carrie. Let's talk about indemnity. It's another area in which there are some important differences between the two families of documents. Next slide, Carrie. The consensus docs contains the standard narrow form indemnity with respect to property damage, personal injury, sickness, and death. It's a mutual indemnity requirement imposed on both parties to the extent of the indemnifying party's actual negligence. In the consensus docs, you have a couple of things you don't find also in the AIA documents. One is an ability to recover attorney's fees and costs of the dispute if you are the prevailing party. And when you look at the AIA B101 treatment of indemnification, you'll see no mention of any design professional indemnity obligation in the contract. Although the B103, which is for large complex projects, does contain a limited warranty by the design professional of the owner with respect to third-party claims attributable to the design professional's negligence, and then only to the extent of the unused insurance coverage proceeds. There are some other indemnity issues in the two documents. Next slide, Carrie. The owner indemnity in the consensus docs runs to the unpermitted use of the design professional's instruments of service. You know, after the project completion, the owner is allowed to use the instruments of service to maintain, to renovate, remodel, or expand the project. But if the owner engages in any unpermitted use, then the owner indemnifies the design professional for any adverse consequences of that unpermitted use. There's a separate design professional indemnity for negligence-caused project delays, and there's also a mutual copyright patent indemnity obligation. So that, for instance, if the design professional selects a patented or copyrighted system or method or material, and doesn't have permission to use that system, then the design professional agrees to indemnify the owner and the contractor with respect to the use of that system on the project. And the owner makes the same kind of indemnity promise to the design professional with respect to all other copyrighted or patented systems or materials that are used on the project. You know, once again, the AIA is silent with respect to any indemnity obligation owed by the architect to the owner, but it does impose an indemnity obligation on the owner with respect to third-party claims arising from the owner's unauthorized use of design professional documents. I think to sum up, if you're an owner, you may find better contract protections with respect to indemnity and standard of care in the ConsensusDocs, but if you are a design professional or representing one, it really does not get any better for you than the AIA documents. Next slide, Carrie. And Melissa, I think we're back to you.
Okay. Probably the only area where I see a bigger disconnect between what the documents do and what the project team does, other than project information and contract documents, relates to green and sustainable project goals. You know, I've had a number of times over the last few years where we've been negotiating contract documents on very large projects with, you know, between the contractor and the lender, and for several months, when getting ready to finalize the contract document, I would see for the first time the project scope that the parties had prepared, and take a run through that before finalizing the contract, and see as a bullet point item next to something like a door or a window, LEED Gold or LEED Silver, having a moment where I would look at it again and think, we have been working on these documents for months, and nobody mentioned that there was a LEED project goal, and yet the parties treat it as if it's something like a tree, that can be added in. And I've since learned to ask very early on in the project, is there a LEED goal for this? Because it affects a lot of the differences between the ways that the documents work. I had another project recently where I wasn't involved in negotiating the architect agreement, but some months after it was executed, a client called me and they had gotten a very substantial bill for the architect using a B101 for additional services related to LEED design, paperwork, submittals, and I asked, of course, to see the contract, and they said, well, we told the designer at the beginning that this was going to be a LEED Gold project. Everybody knew that all along, yet we have this huge bill for additional services. Well, that's the way the AIA document treats services related to LEED, is as additional services, but yet the owner had assumed, because that was announced at the time it selected the architect, that would be included in the architect's lump sum price. So there tends to be a fairly significant disconnect between the way owners view pricing for LEED or sustainable services, especially when the goal is given to the architect at the time it's retained, and the way that architects treat pricing for those services. And we'll go through each of the documents individually and discuss that. Carrie, if you move to the next slide. With respect to ConsensusDocs, the bulk of the heavy lifting related to risk allocation and pricing for green-related services is addressed in the Green Building Addendum, which is the ConsensusDocs 310. That document does a very thorough job of discussing and allocating risk regarding green services between the owner, the design professional, the contractor, and if the green building consultant, or the ConsensusDoc term of art, the green building facilitator, is another party, then they're involved in that contract as well. Well, frequently, the parties don't use that document. They rely on what their base contract documents say. The ConsensusDoc 240, with the 2011 revisions, added a recognition in Section 3, which is the basic services section that the design professional will consider green building, the owner's green building or LEED goals as part of its basic services. But after that point, the default is that any additional services would have the expectation of, or any services related to implementing that green goal would be an additional service. And so the document doesn't address how pricing moves forward if there is, in fact, a LEED goal or other sustainable goal. And frequently, especially when pricing is based on a lump sum, the owner assumes that any documents related to LEED paperwork submittals, responding to whether it's parties or the GBCI questions related to those documents are included within the project, where the architect will frequently track those as a time and materials additional service. There isn't any place in the ConsensusDoc form for the parties to specify what the LEED or sustainable goal for the project is. Frequently, the assumption is that this would be done in the program or the Exhibit A information that are attached to the contract. Although frequently an architect is engaged prior to either a LEED certification goal being selected or which level of LEED certification goal will be selected. And given that the parties don't tend to, in an architect agreement, modify the terms of the agreement by change order or some other document to reflect that the project is to be designed according to, say, a LEED Gold standard, the contract is essentially silent on the parties' obligations related to that because it's not specified in the program that's incorporated in the architect agreement. It's merely something the parties identify that they will do and then attempt to design for, but the contract is really silent on a lot of those requirements. And then LEED paperwork submittals are, under the 240, treated as an additional service, as is acting as a green building facilitator if the architect is selected as the green building facilitator, treated as an additional services. And again, the 310 addendum creates or recognizes that on some projects it's appropriate to have a green building facilitator. That party can be, and sometimes is, the architect, and the 240 treats the architect acting as the green building facilitator as an additional service in the default, which raises the question that if at the commencement of or the hiring of the architect, it is intended that the architect act as the green building facilitator, then perhaps it is appropriate for fees associated with being the green building facilitator to be incorporated into the architect's base fee as opposed to having the default be an additional service. So certainly that's a conversation that the parties need to have a dialogue about. Otherwise, the default would treat any of those services as an additional service, even if the owner assumes that because those were part of the initial budget or the initial retention, that those would be included in the architect's fee. Now let's look at how the B101 treats green issues. Carrie, if you'll advance us to the next slide. Now, the current version of the B101 is the 2007 version. About a year ago, the AIA came out with a sustainable guide document, which is the D503, and then subsequently there are AIA documents. Let me back up. The D503 Sustainable Guide is a narrative document that explains certain green building related services and risks, but it also proposes modifications or additional contract language for the various AIA documents to reflect or memorialize the issues that the Sustainable Guide articulates. Subsequent to that, there are now actual, rather than having to compare the B101 2007 to the Sustainable Guide and make the recommendations one by one, it's now possible to download the AIA Sustainable Guide version of the B101 that includes those provisions within the document, which is what makes the B101-2007 different from the sustainable version. It is just the incorporation of those edits recommended in the sustainable guide. The base B101-2007, so for a minute I'm going to go through the B101, ignoring the sustainable guide changes, and then we'll hit this on the sustainable guide changes. So in the actual B101 itself, there is also no place to designate whether there is a sustainable goal for the project. It is assumed that the parties would do that in the initial information or the program information. So similar to the consensus docs, there's not a place to specifically identify that. Within the architect's basic services, in the AIA B101, the architect is required to discuss with the owner alternative approaches to design and construction, including the feasibility of incorporating environmentally responsible design approaches. In addition, the architect, as a basic service, shall consider environmentally responsible design alternatives such as material choices and building orientation, together with other considerations based on program and aesthetics in creating the owner's program. Other than those initial both discussing environmental design with the owner and considering design alternatives and material choices in conjunction with price, that's the limit of the architect's basic services related to green under the B101. Article 4, which is the additional services provision of the B101, lists a number of other services that the architect may provide as additional services, things like providing LEED paperwork or LEED certification services under the AIA's B214, which is a LEED or green services addendum that can be separately executed. In addition, one of the bullet point additional services is, quote, extensive environmentally responsible design, end quotes, which doesn't have much precision wrapped around it and would be a sense of ambiguity if the project as an initial matter had an extensive environmental design contemplated, would seem to give rise to a conflict between what are basic services and what are additional services. Now moving on to consider the recommended changes or the changes that are included in the sustainable version of the B101. The AIA has indicated that substantial completion is not the anticipated date for the award of a sustainability certificate. Most people who worked with LEED are familiar with the fact that it is sometimes up to a year or more after the time the project is occupied by the owner that the GBCI will come back with a sustainable recommendation on or a certification award based on the project submittals. So the AIA recognizes that gap and clarifies that substantial completion does not extend till that sustainable award occurs. In addition, the sustainable version of the B101 includes extensive language regarding what green-related work will be considered additional services. And this is almost a full page worth of language in AIA-sized texts that indicates that additional services will include a pre-design workshop with the owner's consultants regarding sustainable measures, establishing the sustainable objective, discussing strategies for implementing the sustainable objective, impact on the project schedule. In addition, after that, pre-design workshop, that's an additional service, preparing the sustainability plan based on the objectives and measures identified is an additional service. Making changes to that sustainability plan based on the owner's feedback or other project participants' feedback is an additional service. Preparing drawings and specifications that incorporate the sustainable measures is an additional service. which, again, if this is default language that's included in the contract and the parties identified at the time of contracting that there would be a lead goal, this, in the circumstance I related at the beginning of this section was, the basis for the conflict was the architect had clear contract language that said all of these were to be additional services, yet the owner, at the time it retained the architect, indicated that it was going to be a lead project, so the owner didn't understand why it was required to pay additional services for the architect to incorporate those green and sustainable measures into the drawings and specifications, but yet the contract language clearly favored the architect, indicating that those would be an additional service. So it isn't always appropriate for the default to be that those items will be an additional service. Perhaps on a project where the architect is retained prior to the possibility of a lead objective or other work being explored, it might be appropriate for those to be the default as an additional service. The issue gets further more complicated when you are practicing in jurisdictions where there is a required lead certification for all projects, whether those be government or private projects above a certain level. In that circumstance, an owner might be very surprised why the architect would treat, quote, sustainable services as an additional service when those are in fact required by law and prerequisites to get a building permit. In addition, the AIA, consistent with its general tendency to limit liability and exposure for designers, has included in the sustainable version a long clause that basically indicates that the architect acknowledges that the project may require use of materials and equipment that have limited testing or verification of performance as part of the sustainable measures, and that the way that that's treated is the architect will recommend or the products to the owner based on the manufacturer's submittals, indicate to the owner that those materials or systems have limited testing, they might have drawbacks. Then the owner will render a decision regarding the use of the materials, and the architect is not held liable for any failure of those materials. Given that most building owners are not sophisticated consumers or sophisticated in the sense of understanding the performance or suitability of product specification or selection or systems, that seems a very strange risk to shift to the owner, but yet the AIA has come up with a mechanism for parties to do that, and that would be another one to flag to consider whether it's appropriate for your contract, especially if you're representing a party other than the architect. In addition, the sustainable version also has come up with additional service language with fill in the blanks to indicate that any of specified services above a certain level will be treated as additional services. Those include revisions to the sustainability plan above, a fill-in-the-blank number of revisions, or submittals to the certifying authority above a certain number, and responses to comments and concerns above a certain number will be additional services. One thing to consider is whether that's an appropriate additional service. One could argue that if there are any number of revisions to the sustainability plan needed, it might be because of the architect's failure to adequately develop that plan in the first place. Or if there are a number of responses to the certifying authority's comments and questions necessary, is that because the architect didn't fully or clearly address the issue in its plans and specifications that necessitated the certifying authority to ask a question regarding clarification? If that's the circumstance, is it then appropriate for the owner to be required to pay the architect both to revise the drawings and specifications and respond to the comment? So you can see some of the tug between what the default language is in the AIA, which is very architect favorable, and how that might be different than what an owner's reasonable or default expectation would be if a project and a green objective are either identified very clearly at the beginning of the project or required as a matter of law. Go ahead and hit the next slide. All right, that takes us to the section on building information modeling.
Thanks, Melissa. It is somewhat ironic that the probably least technologically knowledgeable person is doing the most technologically demanding topic. I do want to follow up on some of Melissa's comments on LEED certification. Our firm recently moved from facilities we'd been in for 20 years and have moved to a new, or actually a renovated office facility in Chattanooga. Our hope, we don't know the answer just yet, our hope is that we are going to achieve gold LEED certification, which was an extremely interesting process to work through in a renovation of an existing building. Anyhow, as I started out before, and let's go to the next slide, Carrie. I started out with this same slide. This is not here, again, by accident. I put it in both places to make the point that with transmission of documents and information, having the major developments and revolutions over the last 30 or 40 years, BIM has really occurred in really more like the last 10, no more than 15 years. And the technology that makes BIM even possible is really the tail end of this technological development, which is the interactive databases and cloud computing. Gives people the ability to have a database floating around out there somewhere that different participants can access, make changes to, and have a more collaborative process in the design of a building. Next slide, please. And one word about collaboration. There's, by the way, an excellent source out there called Shared Design. It's also called Shared Design, and so I want to give that plug as well. I didn't write it, but it's a good source. The development of collaboration is not necessarily as recent as we might think. For example, and purely as an example, back in my last career as an architect, it's not at all unusual for us to, doing our drawings, we would send out the drawings, we would receive submittals from various subcontractors and suppliers, and just, for example, casework and millwork, we'd review the submittals. Well, we didn't design how that casework and millwork fit together and how it was affixed to the building and all those sorts of things. We designed what we wanted it to look like. In effect, we let someone else design the workings of that casework and millwork. And so it's an idea that's really older than we might think. As you look through the development of collaboration, you'll see what happens is you go from shop drawings to ideas like performance specifications. And I'm not talking about the performance specifications that we used to put together just to get one particular manufacturer's products used. I'm talking about performance specifications in the sense of a true performance spec that says we want this widget to perform in this way. You make it do that. Another example of collaboration, value engineering. That's the tail end of collaboration. It's almost too late sometimes, but it's not unusual. You send the bid documents out, you get the prices back, you make changes. The whole idea of design build is, in a sense, a further development of collaboration or collaborative design. Partnering, a buzzword that was used more maybe 10 years ago than it is now. Same approach. And the whole idea of BIM is, okay, we've got this great technology. How can we use it to do a better job of getting our buildings designed and built? Next slide. It's worth going through how the AGC and the AIA look at BIM and collaboration. This and it's one of the very few slides that I will read, is the definition from the Contractor's Guide to BIM, which is an AGC of America publication. It says, building information modeling is the development and use of a computer software model to simulate the construction and operation of a facility. The resulting model, a building information model, is a data-rich, object-oriented, intelligent, and parametric digital representation of the facility, from which views and data appropriate to various users' needs can be extracted and analyzed to generate information that can be used to make decisions and improve the process of delivering the facility. That's a lot of words. A couple of comments. Number one, the focus on the AGC side is on the model itself. But that focus is not exclusive. If you look at the last phrase, the model is used to improve the process of delivering the facility. Next slide. You'll see on the AIA approach, the idea, which is actually broader than just BIM, is integrated project delivery. This is a guide from the AIA. Integrated project delivery is a project delivery approach that integrates people, systems, business structures, and practices into a process that collaboratively harnesses the talents and insights of all participants to optimize project results, increase value to the owner, reduce waste, maximize efficiency through all phases of design, fabrication, and construction. The AIA approach is interesting in that it stresses more the process than necessarily the model itself. Next slide. When you get into the ConsensusDocs 240 and the AIA B101, both allow for BIM to be used. The ConsensusDocs 240 requires the use of BIM if the owner requires it. Both the 240 and the B101 take you to separate documents to structure how the BIM procedures work. Next slide. On the ConsensusDocs side, that document is the ConsensusDocs 301. On the AIA side, it's the E202. They come at it from sort of interestingly different approaches, although I think they arrive not necessarily at the same final resting point, but at least at the same general goals. Some important parts about the ConsensusDocs 301, it does include provisions specifically stating that the 301 does not restructure any other agreements. It provides that the 301 may be appended or incorporated. That's in 1.3. Doesn't change. It's got a specific provision that says this does not change the designer's obligations or the designer's role. Another specific provision that says does not change any of the owner's warranties as to design, like are inferred by the Spearman Doctrine. The AIA E202, the general provisions there, it requires the E202 to be incorporated by reference into the other agreements. And I will look and focus on the BIM definition in the AIA document, which is 1.2.1 of E202. And I just want to read it to you because you'll be struck with how similar it is to the first definition I read from the AGC. AIA defines BIM as a building information model as a digital representation of the physical and functional characteristics of the project. It's referred to in this exhibit as models. The term may be used to describe a model element, a single model, multiple models used in the aggregate. Building information modeling means the process and technology used to create the model. So AIA does itself focus on BIM as a model. And the last point about the AIA sort of general principles is the idea of levels of development, which we'll look at on the next slide. And in fact, unlike the usual approach I've taken, which is to look at the ConsensusDocs first, I want to look at the AIA first on the level of development. which is in Section 3 of that agreement. Level of development, when you look at it, it may sound a little bit familiar to you if you have worked on architect agreements in the past. The level of development under the AIA is specific content requirements and associated authorized user for model elements at 5 progressively detailed levels of completeness. Now, under the AIA, and you'll see the LODs 100 through 500, they are all designed to be progressively more detailed, each one building on the other. When you look at the LOD 100, that's in general, and I'm not going to read the terms, it's in general, it's overall massing, some 3D representation. LOD 200 is what the AIA calls generalized assemblies with approximate dimensions. LOD 300 has accurate dimensions, and it actually mentions that it's like traditional contract construction drawings. And I guess my comment on those first 3 levels of the AIA approach is they really do sound a lot like the traditional notions that we see in AIA contracts of schematic design, design development, and then fully dimensioned construction drawings. The next level for the AIA is the LOD 400, which includes, in addition to all the others, the complete fabrication and detailing. In other words, you get to the submittal level that I referenced earlier. And then the LOD 500 is simply making changes to what has come before. And when you look at the ConsensusDoc side, it takes a little bit of a different approach. And the models under the ConsensusDocs don't necessarily build on each other. The first thing that you start with, and it's not listed on the slide, is just the general definition of a model. And then from that point, the ConsensusDocs describes various types of models. You have a design model, which to me appears to be more of the simpler initial design documents. There's a construction model that is defined to include the equivalent of shop drawing submittals in 2.2. You have a, I'm skipping one, full design model, which includes architectural, structural, mechanical, electrical, plumbing. You have something called a federated model, which is a model where you can make changes to individual models, but it doesn't change other parts of the model. And then you have what to me appears to be the most detailed under the ConsensusDocs, the project model. And that appears to be, and that's at 2.15 of the ConsensusDocs 301, that includes a full design model plus one or more construction models. So the AIA is somewhat tied to the more traditional approach of the AIA development and design. ConsensusDocs less tied to that, but still has, in general, the same sorts of ideas. And by the way, and this is a note for Carrie as well, I'd like to update that slide before it goes out to include the project model so that when folks get the slides, they'll have that in there. Next slide. Now, how does ConsensusDocs and the AIA approach how you do building information modeling? Under the ConsensusDocs side, you have a primary role of someone called the information manager. And the information manager has roles that are spelled out. In general, it includes setting up and getting access rights and controls for user accounts for all the participants in the process. The information manager takes care of encryption measures, makes sure that everyone is encrypting their data in the same way. The information manager tracks all data entry, has duties for backing up and maintaining the data. So in other words, under the ConsensusDocs side, the information manager is the person with the primary role of sort of keeping track of the model and all the inputs to the model. On the AIA side, the AIA looks at who owns the model, model requirements, and model management. They look at it in a little bit of a different way, but again, the idea is generally the same, that the model has to be managed. Next slide, please. The next important part of the BIM addendum for the ConsensusDocs 301 is what's called the BIM execution plan. Interestingly, this is required to be done as soon as practical, but in no event not later than 30 days after the latter of the execution of the contract between the owner and design professional, or execution of the contract between the owner and the contractor or construction manager. And the BIM execution plan sort of lays out, okay, how are we going to go about modeling, keeping track of the model. It has very detailed requirements for what the plan must address, including things that I have listed there on the slide, the contact information of the various participants, requirements and protocols for how you define and identify and update the content of all of the models. Remember, under ConsensusDocs, there are different types of models. It approaches scheduling and delivery and update of models. And then there are a whole host, and you'll see the reference there, 4.3.9 to 4.3.22. That actually goes all the way to 4.3.29. But a whole host of procedures and protocols from the contributor standpoint, from the maintenance of file structures, software, including things like utilizing BIM on requests for information, utilizing BIM on change orders. So again, a very detailed approach. On the AIA side, they have, in my view, another interesting approach, which is they have model elements, and there's a model element table, which is really a matrix of responsibilities. And the model element table is worth going through, because when you see that in the AIA documents, the AIA utilizes the Construction Specifications Institute uniformat designations. So those, back in my day, those old 16 divisions, now more depending on which CSI format you're using, the model elements are tracked by the AIA in that way. So it's a different setup. The ideas are to get to the same goal. And I know I'm very close to out of time, but I want to add just one final caution, in particular for the lawyers. I think the system's going to work fine as long as the computers are working fine. For the lawyers out there, take yourself back to working on a brief late in the day. You're making sometimes some significant changes on that brief, and you click save on the document on your computer, and something happens. The document disappears. You scream certain words that you can't talk about in webinars. You go run and find your IT folks, and your IT folks come running to your office and they say, "Tim, I am so sorry. That file has been corrupted." Now, I know that happens on briefs. I have heard anecdotally from some architects that the same sort of thing can happen with BIM. I've not seen that case yet, but I'm assuming at some point in time we will, and that might actually be a good lead-in to Frank Briggs on disputes.
Thanks, Tim. Let's first, before we get to disputes, spend just a few minutes talking about owner and design professional termination rights. Carrie, if you'll go to the next slide, and first talk briefly about terminations for convenience. You will find in both family of documents an owner right to terminate the services of the design professional for the owner's convenience. There's a nearly identical language regarding a 7-day notice requirement there. Where the documents differ, though, is in the categories of cost and fees that might be recoverable by the design professional. If you look on the AIA side of the slide, you'll see that the design professional is allowed to recover, among other things, its anticipated profit and a licensing fee for the owner's limited use of the architect's instruments of service, whereas the ConsensusDocs substitute what's termed a termination premium, which would be agreed to by the parties up front in the contract, in the place of or in lieu of both lost profits and a license fee. There may not be great differences here. My guess is that the ConsensusDocs are going to provide an owner with a little more certainty regarding the termination for convenience cost, because you aren't worried about the uncertainty of a determination of lost profits following a termination for convenience. Let's look at terminations for default. Next slide, Carrie. In both documents, you're also going to find a mutual termination for default right. The ConsensusDocs speak of material breaches in justifying a termination, while the AIA speaks in terms of a failure to substantially perform. There's likely no great difference there, just different language, although I would guess that the term material breach has a more defined meaning in the case law than failure to substantially perform. Both these mutual termination provisions require 7-day notice. In the ConsensusDocs, you've got a specific or an express right to cure the default in that 7-day period. The AIA document doesn't mention a cure right, but it's likely implied by law. And the ConsensusDocs does one other thing. At the end of that 7-day period following the notice, if you really intend to terminate, then you have to confirm in writing that the termination is effective. And when you think about all the exchanges of material breach default letters on some troubled construction projects, I think it's probably a better idea that the ConsensusDocs have of actually requiring that someone write a letter saying, I gave you a 7-day notice, the default has not been cured, and the termination is now effective. Next slide, Carrie. Looking specifically at the architect's termination rights, and the one thing I'd like to point out here is that the ConsensusDocs contain a work continuation clause. That is something similar to what you find in the typical owner-contractor agreement, the notion that the contractor, or here the design professional, will continue to work during the pendency of any dispute, and the owner will continue to pay undisputed sums. What's maybe a little different here is that the design professional still has a right to terminate for material breach in the ConsensusDocs. And so the manner in which the work continuation clause and the architect's termination for default rights will coexist is perhaps a little fuzzy, but certainly if you're an owner, you'd much prefer to have a work continuation clause in your contract. There is no counterpart, no work continuation clause in the AIA B101. And in addition to the right to terminate in the AIA document, the architect also has the right or the option to suspend its services after that 7-day notice in addition to its termination rights. Next slide, Carrie. You know, Tim talked about this, and so I'm just going to touch on it briefly. Certainly with both the AIA and the ConsensusDocs approach here, it's important to the owner that it make and continue to make all payments due under the contract in order to be able to use the design professional's documents for permitted uses, including the completion of the project. And as Tim pointed out, without a proper owner payment of all sums due, then the owner has no ownership interest in any of the design professional documents. Let me come back to that concept in a minute, but Carrie, let's go to the next slide. Looking at the impact of a termination in both documents, Here we have illustrated a couple of important differences. On the ConsensusDoc side, if the agreement is terminated for any reason, and that would include an owner default, the ConsensusDocs still allow the owner to use the design professional instruments of service for the permitted uses in completing the project, provided, of course, the owner pays all sums due. Whereas in the AIA B101, if the design professional properly terminates for cause, the owner and its contractors lose all rights to use any of the design professional documents. An owner almost always has a need to make some use of design documents following a termination, and so the inability to do so certainly can be a substantial and sometimes costly loss for an owner. So from the perspective of the owner, the ConsensusDocs 240, I think, does offer some clear advantages with respect to the parties' rights flowing from a termination. Next slide, Carrie, and let's talk in the time we have left. I want to give you sort of a condensed view of the treatment of dispute resolution by both the 240 and the AIA B101. With respect to the AIA process, most of you are familiar with how the AIA dispute resolution process has traditionally operated. It's changed only slightly in the last few years. Disputes still must be mediated as a condition precedent to arbitration or litigation, although the B101 now provides for the option that the parties can designate some other dispute resolution procedure at the front end in the contract. With respect to a selection between arbitration and litigation, the process is a check-the-box kind of approach to that decision, and if you fail to check the box, then the default dispute procedure is now litigation and not arbitration. On the ConsensusDoc side, you see more options for how disputes are approached, and the other thing that becomes quickly evident is that the ConsensusDocs strongly encourage a quick dispute resolution process. Let's look first at the ConsensusDocs approach. Carrie, next slide, please. This is a chart that illustrates the ConsensusDocs procedure and some of the options. It may be a useful outline for you, but let's move to the next slide and talk a little bit about the details of how the ConsensusDocs operates. You'll see on the right side here, and you'll get some appreciation for the aggressive approach to dispute resolution in the ConsensusDocs. You've got two levels of informal settlement discussions that are mandatory, first between party representatives who are to have direct discussions, and then if they don't resolve the problem within 5 business days, it's passed up to party executives, senior executives, who must meet within 5 business days of being informed that the ball is now in their court. And then if the matter is not resolved within 15 days from the first discussion by the party representatives, then the dispute is submitted to either a dispute mitigation procedure if the parties have elected one. And those dispute mitigation procedures are either a project neutral or a dispute review board who are required to make a non-binding decision within 5 business days of the referral of the dispute to them, unless good cause is shown to vary that time frame. That's an option. The parties don't have to proceed to select a dispute mitigation procedure, and if they do not, then the matter goes to mediation through the AAA, and that mediation is required to begin within 30 days of the matter first being discussed by the party representatives and concluded no later than 45 days after that first discussion. And then if the mediation or the dispute mitigation procedure doesn't settle the dispute, it goes to either arbitration or litigation for final resolution. you can tell that there is not a lot of time allowed here in the ConsensusDocs approach for a dispute to linger and grow stale. Certainly, I think some would say in some cases where the issues or the project is particularly complex, those short time frames may not allow sufficient opportunity for an informal resolution process, but of course the parties are certainly free to amend those time frames in the contract, or when a particular dispute cries out for a longer discussion period or a mediation time frame, then the parties can attempt to agree on more time being injected into that structure. It's an aggressive approach, and I think the ConsensusDocs and probably most construction project participants would applaud the notion of trying to encourage quick dispute resolution as opposed to allowing a dispute to just linger for months and years. Next slide, Carrie. I'm not going to spend much time talking about the AIA structure. I think most of you are familiar with it. You know, it really has not changed much. Mediation is still a condition precedent to arbitration or litigation. Mediation can be demanded contemporaneously with an arbitration demand or the filing of a lawsuit, but mediation is given a 60-day period to work its magic before the arbitration or litigation are permitted to go forward. No contractually mandated sense of urgency here with the AIA process. It is a simpler process and one that probably most construction participants are very familiar with. Next slide, Carrie. Let me mention a couple of other details about the dispute procedure. From the ConsensusDocs standpoint, you will see an ability of the prevailing party to recover its attorney's fees and costs, which is something you don't find in the AIA document. The ConsensusDocs also provide that although arbitration will be governed by AAA rules, it's not necessarily to be administered by the AAA. So there are some new notions there. Next slide, Carrie. You know, it's rare these days to find a project dispute which involves only two parties, and I think that's particularly true for contractors and for owners. And it may be important to you, if you're an owner particularly, that the contract make it easier to join other parties to an arbitration, such as the contractor, or to consolidate related arbitrations. And I'm not going to take the time to walk you through this slide and the next one, but let me just suggest to you that the ConsensusDocs make it significantly easier to join parties involved in a common dispute. You'll see on the right side of this slide some of the requirements imposed by the AIA B101 for joinder of additional parties. And next slide, Carrie. And you find the same kind of AIA restrictions imposed with respect to the consolidation of related arbitrations. And some of those requirements are probably frequently, at least will present problems for someone attempting to consolidate related arbitrations. I think what you can conclude from these two slides is that the B101 makes it difficult in many circumstances to get all of the involved parties in the same dispute procedure, and the ConsensusDocs contains or promotes the joinder of everyone involved and necessary to the complete resolution of a dispute. Back to you, Carrie.
Well, Frank, Tim, and Melissa, thank you so much. We have a couple of minutes here for questions. If you have a question, please type it in our questions box. And I do have one question so far. The question is, why is it beneficial for the architect to indemnify the owner, constructor, and others on the site? That which happens on the site should be the constructor's responsibility, is it not? Please explain why this is included.
Carrie, is the question, why is it necessary to indemnify the constructor
question was, why is it beneficial for the architect to indemnify the owner, constructor, and others on the site? The person seems to think that it should be the constructor's responsibility. So the question is, why is it beneficial for the architect to indemnify?
Well, it's certainly not beneficial for the architect, I grant that, but I think, and there are different indemnity provisions in the contract. In the consensus docs, you won't find many on the AIA side, but with respect to those various indemnity obligations, the constructor is, at least in some cases, as likely to be affected by the architect's negligence as the owner, and as between the owner and the architect who has caused the damage as a result of its negligence. I think the notion is the architect should bear that cost and that responsibility, most of which is going to be covered by insurance.
Super. Thank you, Frank. I don't see any other questions coming in, so I just want to thank you all again, Melissa, Tim, and Frank, for a really informative presentation, and I want to thank all of our participants for joining us today. We hope you learned some differences between ConsensusDocs and AIA standard contracts and some practical information that you can take and incorporate into your own practice and businesses and such. Also want to just remind you that if you need any information on ConsensusDocs, please feel free to visit our website, give us a call at our toll-free number, or email us, and that information is up on the screen for you. Want to remind you we will be sending out a few days after the webinar a copy of the PowerPoint, and Tim will make that update you wanted. A copy of the PowerPoint along with a link to the audio recording so that you can view this webinar again at your leisure. We'll also be posting it on the ConsensusDocs website possibly at some point in time. But please go ahead and fill out the evaluation form that will come along with this email with this other information. We'd like to get your feedback, and that will help us plan for future educational events. So this brings our presentation to a close. I hope you all have a wonderful afternoon. Thank you all very much.